My, my role in this part is simply to introduce the conference and to welcome all of you here and handle some logistics before we move on to panel 1, where we're running slightly late, so I'll just try and move things along quickly. Anurag mentioned that the Law Governance and Development Initiative was established a little over a year ago at APU. And we had three main focus areas that we wanted to work on and that we've done work on this year. First, on welfare state design and implementation. In the last year, we focused on the RTE Act, intervened in the legislation and in the litigation in the Supreme Court, and are monitoring and trying to make interventions in the policy of the implementation of the RTE legislation in India. We use RTE because at this point it seems that the RTE is the template for new welfare. Whether it pans out like this is moot, but it's one policy agenda of government that needs serious and critical engagement. It helps us that the foundation has done that for 10 years. So in that sense, we stand on that prior work to engage. The second area that we're focused on is on corruption and accountability. And what we've done in the last year is to look at anti-corruption agencies in Karnataka and done slightly different work. There's a lot of literature on corruption measurement in India, but we're looking at the way corruption agencies work. And there's very little literature on that. And most of you are familiar with the Nepal issues in the last year. And we have a very different perspective on these institutional design questions because of the kind of work that we have done in the Lokayukta and Karnataka. The third theme that we're focused on is on legal system reform, which brings us to this conference. On our part, we're focused on three areas. We've looked at mediation in great detail, mediation in Bangalore, which is one of the biggest mediation centers in India. We've looked at the civil justice system carefully, analyzing the central sort of policy pillar of the civil justice system, which is the relationship between pendency and vacancy. And we're trying to make some sense of why that any other related queries. Manvi will help with any other substantive. If you need some data that we're using or other secondary data, we have a lot of work that we've not put into your bags. So if you need any of that information, please contact Dolashri and she'll help you with that. And Leah will help you with any questions relating to reimbursements and so on. So besides the conference panelists, and we've tried hard to get the best panels that we could, permitting travel and other commitments. We have 9 students who we've invited and 5 faculty members who we've invited to participate and enrich the conversations in this room. Let me start by saying that we haven't planned this conference as if it were a conference on a grand scale, sort of showcasing finished work which is ready to implement in policy frames. We don't have any of those expectations. What we're trying to do instead is to make legal system reform a serious field of inquiry. And that is the focus of the conference, and you'll see that many of the presentations are early stage presentations. And we've called some of the younger scholars to this room. So it's in that spirit that we start this conference, and I'll hand over to Ram to begin with the first panel. Thank you. The podium very quickly, but it's the last time that I do this. So I'm going to take some time to try and outline what we are thinking behind the ideas behind this conference, and to try and outline what kinds of problems we think legal system reform needs to address in India. I'm going to start though in a very different place, away from the academic literature. I'm going to start with Vijay Tendulkar's celebrated Marathi play, Silence the Court is in Session. The rough translation, and since I don't know Marathi, I'll stick with that. Arguably the most insightful parody in Indian literature on court systems. And surprisingly not, given the current environment where everything gets censored, either by Parliament or the courts, it's quite surprising that this has not been censored at all. And like all successful parodies, it's deeply insightful because it hits upon some remarkable truths and then builds on that to tell this remarkable little story about the way Indian law operates. For those of you who are not familiar, it's a play by an amateur, semi-rural or semi-urban troupe. They go off to a new venue and they want to stage a trial of Lyndon B. Johnson for developing nuclear weapons. As they prepare for this trial, it's a staged play, they decide to practice, to do a sort of mock version of the trial in preparation for the real performance. And what it ends up being is a very incisive trial into the personal conduct of a 34-year-old single woman teacher who is part of the troupe, and her life story becomes the focus of the trial. And that's the sort of the treatment in the play, and it makes for great reading. Vijay Tendulkar's very perceptive. The play starts with one of the councils pressing for a 15-second adjournment because everyone needs to use the spittoons to clear their pan, and so it continues with very tightly drafted pieces of putting this remarkable story of a court trial together. It's not a play that sticks to the script in that it's not terribly legal, in that it's more a human account of someone who has aborted a baby, and that's the focus of the play. What is striking in the play is that it does a few things that you'd never find in an Indian courtroom, which is that the entire evidence, the argument and verdict happens in a single day, in a single sitting. And this is what is called, in the literature on legal system reform, it's called outcome date certainty. That you know when the trial will finish. And it might be purely for dramatic effect that Vijay Tendulkar uses this form, but interestingly, it might be the most important thing in that play, which somehow the sort of the leading lights of legal reform in India have never got around, despite the extensive analytical and theoretical work that has gone behind legal system reform. No one has ever spoken about this as being a sort of a key to getting the Indian legal system to work. He also does something else. He shows us that there's very quick disposal. It's disposed. The person's found guilty, and in this case, it's a mock play, so it's not legal outcomes, but the outcomes of social censure are damning and very effective in this case. But what's striking is that what the play reinscribes in its outcome is so fundamentally socially conservative expectations of what single women should do in India. So the outcomes are brisk and delivered, but not outcomes that one might generally desire in any legal system. So what you get in Vijay Tendulkar's piece is quite a remarkable account of what is happening in Indian law. In two respects, that it's in the everydayness of Indian law, it's quite this sort of it's banal and never-ending. He brings it to brisk conclusions. At the end of it, we don't seem to do very well in outcomes. So even if we take a narrowly instrumental view, and some of the conference panel description and the background note might suggest that we might be guilty of doing that, of taking a narrowly instrumental view of institutional reform. Even if we get it right, that we get a brisk and efficient court system, if we have a court system that reinforces social hierarchy and this kind of outcome, then we won't get very far anyway. So Vijay Tendulkar, in that sense, is insightful on this respect. as well, that we would do badly to just focus on a narrow institutional account of legal system reform. But strangely, in India, the structure of academic literature has recognized this earlier, much earlier. And here I'll just use his two bookends, the two Bakshis. Upendra Bakshi, in his early work in the 1980s, Ram cited the crisis of the legal system, points out very strongly that we should not, with legal system reform, end up creating such a powerful court system that is deeply oppressive and regressive in an Indian social context. He even suggests that what passes for legal reform is merely an increase in state power through the expansion of the legal system. So he suggests that this is an oppressive agenda. He's very skeptical of the rule of law claim and the access to justice claim, and so on. Ironically, the bulk of the book, the remaining part of the book, details why the delays of the legal system have have perverse social outcomes. So, in a sense, the introduction and his theoretical work, to my mind, sits quite contrary to what the rest of the book so convincingly demonstrates. That if you have a legal system which doesn't work, the people worst affected are the poor and the marginalized. I'll just cut across to my other bookend, which is Pratiksha Bakshi's work in 2007. I just use this as much I'm not suggesting that this is the entire literature. I'm just using these as symptomatic of where the literature goes. And she rehearses that argument in a 2007 article where she suggests that the access to justice and rule of law type reform agendas, they're all narrowly instrumental. One focuses on access, they focus on the access part of access to justice, and the rule of law part is just a narrow instrumental institutional institutional delivery kind of argument. And so what you get in the Indian literature, just this sample of the Indian literature, is a deep skepticism about the possibility of meaningful legal reform that enhances social welfare. It seems that a serious engagement with legal system reform, that is, if we improved our court system tremendously, we might end up with only enhancing the power of the state and might end up with a more oppressive political society. And so that is the point that I want to start this conversation with, which is that, is this necessarily the case? Can we provide or can we develop an account of legal system reform that doesn't suffer, at least with the extreme case that the two Bakshis suggest? Interestingly, I'll start with where Pratiksha concludes, and we were very keen to have Pratiksha here herself, but for various reasons she couldn't make it. Pratiksha concludes looking at Harsh Mandar's Nyayagraha experiments in post-conflict Gujarat in 2003 onwards, and suggests that that kind of social dispute resolution, that is non-state communitarian dispute resolution, to be fair to the piece, it doesn't argue that that is the way we should go, but in the way the piece is structured, it suggests that that is the way we should think about the nature of dispute resolution, and that this might be, in some ways, a uniquely Indian or a developing country view of how legal system reform should proceed. So, in the second part of my of this talk, I want to focus on this, on informalism and non-state dispute resolution as being a key vector in thinking about legal system reform. So the Nyayagraha example in post-conflict Gujarat emerges from the recognition that even if you improved access to the state courts in Gujarat, justice outcomes were not delivered. And that is true. In that sense, to the extent that the data available on Gujarat in 2003 suggests that you had a problem of a wicked legal system, which is an exceptional problem. A legal system that itself seems to be oriented towards perverse aims. So it might be a fair characterization of what was happening in Gujarat at the time. But what she suggests is that social workers can bring about conciliatory settlements or solutions to disputes among various parties effectively. Now, I want to start my analysis of this prospect with Galanter and Krishnan's work on the Lok Adalats. For those of you familiar with this literature, it shows that Lok Adalat type proceedings, which are not fully, they're not non-state and they're not communitarian, they're communitarian in a sense, tend to have evolved into exercises of charismatic or patriarchal and very occasionally matriarchal authority, where judges are able to wield, or retired judges are able to wield forms of social power unregulated by the requirements of due process to certainly resolve disputes. They do a very good job of resolving disputes if numbers are the basis of evaluation. But the outcomes of those disputes leave much to be desired, and the process of resolving disputes leave much to be, are certainly subpar. Mediation in India has tended to move from a consensus-based authority, which is the legal foundation of mediation, to a similar sort of charismatic or patriarchal authority format in the way mediation's practiced, even in the boundaries of the Indian court system. The court process, and because Pratap said, I'll just use his work as an example. The formal court process, which is supposed to be bound by all the norms of process, legal process, has also started in India to resemble, to emphasize the values of compromise and settlement. Adjudication almost looks as like the judges are trying to find some reasonable settlements that parties can agree to and live with. And that sense of informalism has crept into the formal courts, where adjudication is seen as this master exercise in social conciliation practiced by judges, unaided by law often. So you have along the spectrum of informalism the truly non-state adjudication as well. You have people's courts of the two varieties. The people's court of the Maoist movement, which are not strict adherents, let us say, to due process, but you also have the people's tribunals of civil society movements, which follow due process in form more often than not, but do so in an almost caricatured format of what a court must be. So you have in India, I suggest, a range of informal methods of dispute resolution that in various ways some may rely on the court system and some may not, but seem to be, for some participants in this debate, the more successful way of resolving the problems of the Indian legal system. So I started with an account of legal system reform that one might find from people who would identify themselves as on the left of the political spectrum. What is interesting is that this informality finds acceptance across the political spectrum. So the World Bank's Justice for the Poor program, it's called the J4P program. A major prescription is the avoidance of the court system. Its major prescription is that to address issues of poverty and exclusion, the best way to go is to use paralegals and non-court based resolution. The latest work in this area is by, it's called the Strategies Towards Basic Justice Care for Everyone report, which is, I think, 4 days old. And its major prescription is this: the role of facilitators and paralegals working towards settlement as one of the best strategies to promote access to justice. So you find a curious coming together of very diverse political agents. I mean, people who identify themselves as being on two different sides, seemingly come together with the prescription that informal approach to dispute settlement, a community-focused approach, is where the solutions to legal system reform are. So while we need not assume as we start this discussion that a state-based dispute resolution system must be the centrally located as the main pillar of dispute processing in any society, we must seriously ask whether, and study in an empirical sense, whether these other forms of informal dispute resolution truly bear out on this promise. That is, that they do not have the hazards of process, but they provide justice-enhancing outcomes. Now, you might find that I've started, for those of you who paid attention to the schedule, I've started this conversation with a theme that is barely addressed in the rest of the conference. And there is a reason for that, to my mind, which is that we have not done any work on this aspect of the court system. We have looked at mediation outcomes, and we are very skeptical of the broad brush claim that mediation disposal, that is a disposal rate analysis of mediation, is somehow maps on nicely to this justice enhancing type outcomes that people make it out to be. So I sense that this is a central question in legal system reform, the state versus the non-state forums for dispute resolution. It is not a question, there are others we have a panel on alternative dispute resolution that skirts around this issue. We don't have anything on the Maoist courts, and we don't have anything on the people's tribunals. But I don't think that literature is readily available. It hasn't been done, and it needs to be done. And that is one central question that legal system reform in India will have to address. What is the extent to which non-state dispute resolution will come to dominate legal system reform? So that's issue one. So the second thing that I will turn to is the formal legal system. And here I want to organize the theme. Yeah, are you taking my time? Okay. I want to organize the discussion as one about bridging academic and policy debates. And I'll try and suggest reasons for doing that. The central concern in policy debate in India has been court congestion and backlog. Now, this has become almost the singular problem that legal system reform advocates in government and on the boundaries of government, that is the institutions around government, have come to stress. Elizabeth Kolsky, in her history of early colonial government in India, suggests that the colonial government was never interested in building vibrant criminal law institutions, because if they did that, if they spent a lot of money on that, it would hurt very much the planter economies that were trying to be developed at the time, and that it would not only stall the project of the plantation economy, but also potentially stall the projects of racial superiority that were integral to that part of colonial history in India. What's interesting in Kolsky's work is that she sees that underinvestment in a legal system, it damages the interests of the most marginalized. And that comes out very clearly in her work, in a way that in subsequent literature on this topic is completely lost as to who does a fully functional legal system serve. So while Kolsky focuses on the criminal law, Mendelssohn and Portage focus on different aspects of the civil law, on the land revenue system, and in Bengal and then in Punjab. And what you see in this literature is the emphasis on a peculiar cultural problem in India, which is the frivolous and vexatious litigant, as being a central figure and a problem in Indian law. And this, incidentally, has remained. Today, the frivolous and vexatious litigant most often referred to is not the land revenue, not the patadar of the time, but the woman who is harassing men using the Domestic Violence Act. So the narrative has remained about frivolous and vexatious litigation, but very little analysis of what that really means. What kinds of interests motivate people to be in the courtroom? And we have a very interesting presentation later on Pakistan on the interests that motivate parties to come to court. But these two issues, court congestion and frivolous vexatious litigation, were picked up by the Rankin Committee in 1924, which studied civil justice pre-independence and said that these are the two really serious problems that we should contend with, and somehow this has become the template for policy discourse in India ever since. Every subsequent law commission report and government body seems to repeat these two elements as being somehow the best explanatory indicators. This is what we must study. If we can get rid of court congestion and if we can get rid of the frivolous and vexatious litigant, then Indian legal system reform will get home. So you find that the policy prescription then is simple. We must dissuade the frivolous litigant and we must enhance the capacity of the courts. And these two dominant ideas have captured legal system reform in India. Having said that, I would identify 2 or 3 other trends, and I'll do it just telegraphically for now. The use of special courts. So wherever we found that the courts were getting congested, we just create new courts. We create debt recovery courts, we create tribunals of various sorts, family courts, consumer courts, and so on, and then find usually a decade later that those courts are in no better shape than the regular court system. The procedural reform, that's adjournments and bail plea bargains. I'll just give you one example here and I'll quickly move on. A curious thing is plea bargains were put out as being one of the most important ways and pushed by multilateral institutions as being one of the significant ways of reducing congestion in the criminal court system. And I would ask you to guess how many plea bargains have been recorded in India in the last few years. And I can tell you anecdotally, though we're struggling to get data on this, that the answer is 0. And there's been no plea bargains recorded. And the approach to legal system reform, this is legislative reform, has been simply to bring piecemeal reform either on adjournments or on plea bargains, as if these would sort out the problems of congestion and the frivolous litigant. We also have seen diversion as a major strategy, arbitration, mediation, and other forms of non-court dispute settlement, of which we find in a brief summary that mediation is the only format that seems to at least deliver disposal rates. The other forms have not even delivered on disposal in our diversion strategies. So I think I have 1 minute left. So let me try and pull this together in a new way. So the policy debates in India are quite stagnant as to what is needed to be done. I don't know what the problems are, but the solutions are the same. The solutions are you tackle court congestion and you deal with the frivolous litigant. You tackle court congestion by enhancing number of judges and number of courts, and you tackle the frivolous litigant by changing legal rules. And if you do these two things, the legal system will somehow become a well-oiled machine. There is no clear direction that one can decipher on the way this is going. The recent talk about court management and so on has hardly been implemented, so we don't know where court management is going to go. But I'm going to suggest to you, and I'll close here, that this is unlikely to even get off the ground because the approach to legal system reform is fundamentally uninformed by the kind and quality of empirical data that is necessary for this project to get underway. If we take easy resort to strategies that have been developed and worked in other jurisdictions, and here I just hold an exhibit A, the plea bargain, it is very unlikely that given unless we are given another institutional environment for the legal system, that any of these will work. And case management, insofar as information is publicly available, seems to belong to the same class of reforms. It has been used in other jurisdictions relatively successfully. Is it going to work in India? There doesn't seem to be a reasonable basis to believe that that will happen. And I say two things here. Then what kind of empirical data? Clearly, quantitative data in India is very poor, and we don't need quantitative data at aggregate levels, which is what is available today. The interesting work of Arnav Hazra and others, and some of our own work, suggests that what's important is local and disaggregated data. Disaggregated by case, by court, and by type of process, and you can't have these national prescriptive forms that will somehow do magic in India. That's the first thing that we pick up. Second, that you cannot do this work without qualitative empirical data. And here I'll just use one work that I think is just about the only work that I can cite that gets here, which is Barry Walsh's work using the ADB studies on empirical studies on the courtroom in New Delhi. And you see that Barry Walsh's work comes up with very different conclusions to what the rest of the legal fraternity, that's the political and legal fraternity, seem to think are the solutions for legal system reform. And I'll just conclude with Barry Walsh's work as an example of how this might change. He suggests that the most important thing is not precisely what process you follow, how many adjournments you allow, whether it is 3 or 5 or 15. What he suggests is most important is outcome date certainty. And the reason that outcome date certainty changes, it seems to be this factor that, and he has a sort of a game theoretic explanation of why it works, is that it changes litigation expectations. The moment parties know that this is the end date of a dispute, it completely changes how parties relate to a dispute. It changes motivations for settlement. And there is no legal system in the world that processes through formal dispute resolution more than 25 to 30% of the disputes that enter the system. There's no other example of any legal system. So what has happened in India is that if we continue with a sort of narrow institutional account, as rigorous as our econometrics might be, of how institutional reform must proceed in the formal legal system, we are very unlikely that we will get anywhere with this phase of reform. And it's in that sense that our work at the Law Governance Development Initiative, we're trying to address that very problem. What is worrisome for us is that most of the policy participants in the debate and key actors seem to think that the academic work has already been done. And they seem to think, and you will hear some of them present later in this conference, they seem to think that the thinking work is over. All that needs to be done is execution. The templates are ready, and none of these, ironically, none of these templates or data sets are available in public, so we don't have a traction on what they are thinking or what they propose to be the next magic bullet. But the worrisome part of this conversation is that the policy space today is almost completely severed from the academic conversations that need to happen around these important issues. And so let me just conclude by saying that we don't think that legal system reform has any meaningful prospect of success unless it is backed with very serious work on a normative understanding of what forms of dispute resolution are justice enhancing and promote an equitable society. And that normative understanding cannot proceed without a deep empirical engagement with the functioning of the formal legal system as well as the informal legal system. But unless we do this in a quantitative and qualitative way, that this project of legal system reform is likely to remain in kind of the situation that we are in for the last 100 years. Thank you.